It's Andrew here from the Australian Bookkeepers Network, and this morning we're pleased to present Maria Nikoletatos, from the Chief Knowledge Officer from the Australian Payroll Association, to do their Awards Masterclass webinar for you. So I'll now pass over to Maria and she'll get started on this morning's presentation.
Thank you. Hello everybody and welcome. Please, firstly, I hope you've all had a lovely weekend. Secondly, please forgive me, I did speak for 7 hours on Thursday and 7 hours on Friday, and I have another webinar, so eventually my voice may go. Please forgive me, and if you're having trouble hearing me or anything like that, please let me know. Okay. Today's presentation is, I know it's called an Awards Masterclass, but what we're going to do is really look at the modern awards, the structure of the modern awards, how they apply to employers based on industry or occupation, or a bit of both. So let's start with what we will look at. It looks like a blank screen. Okay, sorry about that. We'll look at how modern awards apply to employers. We'll have a look at the structure of most modern awards. Typically they're all the same. They've got the first bit which tells you what the award's called, and then the second bit when it came into play, and then the third bit when it pretty much tells you the definitions, if you need to refer to whatever, if it constantly refers to a particular expression, what that expression means and what it's defined as. It also then goes through Section 4, as I said, 3 is the definition. Section 4 is generally who the award covers, and that's what we will look at. Also in all the awards, whether it's in Section 4, whether it's in Section 5, whether it's a schedule at the bottom, there is a classification structure. That too is very important in determining if, first and foremost, if that award applies to you, and how to actually classify somebody to the best of your ability, of course. What we need to understand is that I suspect as bookkeepers you're not actually working for the employer. You may be running their payroll, but you're not working for the employer. So really, I guess it'd be difficult to classify someone. The fact is, did you hire them? Did you do the role description? Did you define the role and classification as per the award? Sometimes it is difficult to classify someone when you're not actually involved in the operations of the business. We'll also look at penalties and loadings versus overtime. We'll look at casual employees and some certain entitlements that are for casual employees under some modern awards. We'll also have a look at just a couple of cases of what can go wrong and the consequences of it going wrong. Okay. And I'm not sure if Andrew mentioned it, but I believe if you have any questions, please enter them into the question box. I can see the question box, but I am technologically challenged. So I'm hoping if there are any questions, I do see them. Otherwise, I've closed a box inadvertently that I didn't mean to. Okay. This is the hard part, really, once again, because you're not necessarily working for the employer and know the ins and outs and the operations of the business. But generally, modern awards apply to employers in one of 3 possible ways: under an industry award, under an industry and occupational award, or simply an occupational award. And from what I understand, they still are transitioning some new awards. For example, I've been told that there's a Telstra 2016 award, and clearly that would be for Telstra employees only, but it is a modern award that would apply to them. So there are some industries that are still in a transitional phase that's probably been going on for a while, and that particular organisations will have their own modern award. Okay, when we're looking at what to consider when we're determining which modern award applies, could possibly apply, doesn't apply, does apply, it is quite difficult because a lot of industries overlap, and in some, although the award may cover that industry, the operation of the business actually belongs in that industry, that award, although it's titled that industry, may not necessarily cover the employer's business. So we look at a bit of a tier structure. So we have a look at an award that we believe would be most relevant, and that would be the industry award. If there's no industry award, we need to then consider whether an industry/occupational award or an occupational award on its own will apply. Then, if all that fails, we have to look at whether the miscellaneous award applies. And from my understanding, not having a totally HR legal background, the miscellaneous award isn't an award that you simply shove people into because they don't fit anywhere else. The miscellaneous award came about from, don't forget, before these 122 modern awards became, before they came in force in 2000, pardon me, and 10, we had thousands and thousands and thousands and thousands of state awards belonging to each state and territory. And basically the government at that time said, bye-bye thousands and millions of awards. We're going to have 122 national awards, modern awards, that apply to employers in the national system. So not state government, New South Wales government, Queensland government, that sort of stuff, but national employers. Once again, those awards contain things like, I was listening to a webinar hosted by our workplace/industrial relations associate, and we were listening into one of their webinars, and they had some sort of award, and it was from the 1900s when they used to do horses and carriages and stuff like that, where a lot of those roles and the classifications in that award weren't applicable. So there were lots and lots and lots and lots of those types of awards that they pretty much said, we're going to have to put a miscellaneous award into play to cover these type of people that were already covered under an award. If the role was never initially covered under a pre-modern award, don't be putting it into the miscellaneous award. Don't be classifying that person under, that employee under the miscellaneous award. Basically, if the role wasn't covered in a pre-modern award or a state award or anything like that, and it's not covered in the modern award, that person would be what we call next step down award 3. There was nothing ever covering them in award, a modern award, a pre-modern award. So you can't just be putting them now into the miscellaneous award, which some employers tend to do. Okay, what do we mean by industry awards? Okay, clearly industry is quite a common term. You'd pretty much know if you were in an industry or not. So if you're in your local RSL clubs, that would be in your hospitality industry. Or if you have registered clubs, they might be, the RSL may very well be a registered club, but if you have your other bowling clubs and stuff like that, you have registered clubs awards and you have hospitality. So you can see they're both in the hospitality industry, but you'll have to look a bit further because there is a registered clubs award. So when we look at the industry, first we must have to, we look at the definition of the industry in the award, and number 1, the employer must operate in that industry, and number 2, the employee's job must fall within that award a classification that's in that award. So, I mean, the common one everyone looks at is, the common one that everyone looks at is the hospitality or the general retail, but I thought I'd just have a quick look at the amusements, events and recreation award coming up to the festive season. So in this award it says, this industry award covers employers throughout Australia in the amusement, events and recreation industry. And it goes on to define in section 4 of who this award covers, the coverage section, and you can see it says, amusements, events and recreation industry means the operation of leisure and recreation facilities and centres, sporting exhibition convention centres. I mean, I'm sure you can all read zoos, agricultural and horticultural shows, carnivals, amusement parks, 10-pin bowling. Pretty much your standard amusement, event and recreation facilities. So your theme parks, everything like that. However, it also goes on to say that there are some exclusions, right? And it says that this award doesn't apply to the following. So employers bound by the following awards obviously don't fall under this award. I don't know how, in what way, shape or form the amusement, events and recreation award is associated with building construction, but if you're bound by that, you're not bound by the amusement, events and recreation award. Same with electrical, electronic and communications and contracting award. The two that are most used most interchangeably would be the Travelling Shows Award or the Fitness Industry Award. So if we go back and look, we think about a travelling show, you might think of the Easter show. To me, that's a leisure and recreation facility, not necessarily a centre. It is a carnival and an amusement park. So is a circus. However, they would fall under the Travelling Shows Award. So you have to kind of read what the award covers and then look for any exclusions. Furthermore, it also says very much up the top, leisure and recreation facilities and centres. So a lot of people tend to put gyms and facilities that may have a childcare centre and they have other recreational facilities. But basically, that sort of facility and venue would sit under the Fitness Industry Award. First and foremost, because the major operation of that business would be the fitness industry. So they might have indoor basketball, indoor soccer. Clearly I'm not playing the indoor sports, but all that, the majority of the facility is purely sporting and fitness based. So it wouldn't fall under this Amusement, Events and Recreation Award. Although you might have a swimming pool where the kids can play on the slides and they have an obstacle course and it's recreational. The point is it's a sporting facility and would sit under the Fitness Industry Award. So make sure that under the definition of that industry, and especially the name of that award, Amusements, Events and Recreation, look at what's in it and look at what's excluded. The same concept goes for the General Retail Industry Award. It specifically says this, 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 this and this, but it excludes, you know, A, B, C and D. So you have to, especially that industry award is very, very, very specific and goes on to give you several examples and many circumstances of industry that would fall under that particular award. Okay, if you can't find a particular industry award that you're looking for, you could very well be covered by an industry or occupation, industry slash, first let me clarify, slash occupational award. So the example that many people use is the Health Professionals and Support Services Award. So, pardon me, under that award, there's a definition of who the industry covers, and the industry covers people or employers throughout Australia in the health industry and their employees in the classifications listed in the clause. But if you look at Part B, it also covers employers engaging a health professional falling within those classifications. So although the industry might not be the health professional industry, this award also covers employers engaging a health professional if they fall into one of the classifications that are that are there in the Health Professionals and Support Services Award. I'm trying to think of something like off the top of my head at the moment, but you could very well have a health professional or a support person that's working for an employer that is not in that industry. You may have an in-house health professional in banking industry. You might have, I'm not sure, a masseuse that comes around or something like that. So although not in that industry, they could very well be covered under the Health Professionals and Support Services Award. Okay, and then we go, if all else fails and we can't find the industry and a classification in a particular industry for the role, we then look at occupation awards. And the classic example for this one is the Clerks Private Sector Award. So the tendency is, though, I mean, just by its name, the Clerks Private Sector Award, naturally you would presume that clerks would be covered under that award. Not necessarily. The Clerks Private Sector Award does certainly cover clerks, yes. However, if there is a classification in your relevant industry award covering that clerical employee is not the Clerks Award, it is the relevant industry award. So if, for example, let's say the Aged Care Award, and I'm making this up because I can't remember them all off the top of my head. If, for example, the Aged Care Award has a classification for a clerical or administrative person, so someone that's doing some accounts payable, receivable, even payroll, any sort of filing, reception, clerical type duties. If those duties exist in the relevant modern award that covers that industry, those employees are covered by that industry award, not by the Clerks Private Sector Award. So let's say manufacturing, I don't believe has a classification for a clerical employee. So possibly the clerical employees in a manufacturing environment or industry could very well be covered by the Clerk's Award. Can you all just bear with me? I believe I've got a question, just a moment. My daughter is a clinical pharmacist in nursing home. I believe she comes under this award. I'm not sure what this award is. She could very well come under the aged care award if they cover nursing homes, but feel free to send me an email. I can look at that award for you. She could very well be covered by the health professionals award, which actually a clinical pharmacist possibly not. I'd have to have a look at the definitions. As I said, I'm so sorry, I just don't know them all off the top of my head. Okay, but whoever did, I believe Linda sent that, and I will send you an email if you wish to send me an email after the webinar. Okay, as I said, the common mistake is to classify somebody under the Clerk's Award when in fact they have their own industry award. And there you go, I should have just moved to the next slide, because in the Health Professionals and Support Services Award, it has its own clerical classification. You can imagine you have medical receptionists and stuff like that. So the likelihood is you have a clerical/administrative classification in that particular industry. But as I said, if you think about travelling shows, and actually that's not true, there is an accounts classification in that award. But other awards that, as I said, manufacturing I don't believe has one for a clerical classification for someone employed in clerical capacity. So we've looked at, basically in all modern awards, clause 4 is the coverage clause, and you need to sift through that with a fine-tooth comb. As I said, I was listening into a webinar given by a lawyer around this subject, and they were going through a case at the moment where there was a particular employer who had a potatoes, vegetable type processing facility, and they used to pick the potatoes and process them and peel them and everything like that. And part of the operation had its own kind of shed that was away from the farm. It was on a dirt road, but it wasn't actually on the farm. And under the Horticulture Award, the Horticulture Award actually covers employers whose business and operation runs on a farm or a rural type property. So they're actually they're farming, and farming includes packing, picking, sorting, everything like that in the award. However, this particular organisation was in the process of making an enterprise agreement for its firm, for those of you who aren't aware, the EA, the enterprise agreement, is an agreement between the employer and its employees. It doesn't apply to anyone else who's not using it. So, pardon me. Let's say it was Vegetables ABC wanted to enter into an agreement with their employees, and in order to get this agreement through Fair Work, it has to pass this Better Off Overall test. Now, whilst the majority of the business operation was under the Horticultural Award, the people that were working and packing in the storage facility that wasn't located on the farm were actually classified under the Storage and Wholesale Award. So when they tried to put the agreement through, they used the Horticulture Award as the base, as the underpinning and underlying award. And when it got to Fair Work, the union objected and said, no, these guys are under the Storage and Wholesale Award, and the rates are significantly higher. And in the end, Fair Work ruled, yep, you can have the agreement with the rest of the employees, but your other guys, these guys in the shed, although they're the same employer and the employer mostly operates on a farm, they actually came under the Storage and Wholesale Award, so the EA would not apply to them. So once again, what I'm trying to say is you may have one employer who handles one business but could be covered by a multitude of awards, and that's your worst case scenario. So have fun with that. All right, we've looked at how modern awards apply to employers in the national system, and now we're just going to go into a bit of depth about the structure of the modern awards. Now, you get your very simple awards. Some are only 15, 20 pages long, and others are 115 to 120 pages long. But basically, the structure is quite similar. After you have your introductory bit and your definitions and your coverage, you then have a bit of a dispute resolution process which you have to abide by, and it refers to the Fair Work Act and the measures required in the Fair Work Act for resolving disputes. But then you come to, generally, the next part down is your types of employment. And once again, each award has its own definition of what a full-time employee, what a part-time employee is, and what a casual employee is. In most modern awards, I can almost guarantee you that a full-time employee is someone who's contracted to do 38 hours a week. A part-time employee can vary, and certainly the terms and conditions of a part-time employee can vary. So I've taken a slab out of the Clerk's Private Sector Award just so we can have a look at what a part-time employee is. So under this award, it has specific instructions for a part-time employee and specific conditions, and it says someone who's engaged to perform less than full-time hours, no problem. On a reasonably predictable basis, again, no problem. Part-time employees entitled to pro rata entitlements, not a problem again. That would apply to leave accruals, the rate of pay, because at this stage there's no loading involved. So it's more when I get down to clause 11.6, and it pretty much says all work in excess of the hours agreed under this under clause 11.3. And when we look at 11.3, it says at the time of engagement, the employer and the part-time employee will agree in writing on a regular work pattern, specifying at least the number of hours worked in each day, which days of the week they will be worked, and the starting and finishing times. That's quite specific. You're under this Clerk's Award and you want to employ someone part-time, you need to tell them you work Mondays, Tuesdays and Wednesdays, 8:30 to 5:30. They're your fixed hours of work. Under this award, your employee needs to have in writing a regular work pattern showing the number of hours worked each day, which days, and the actual starting and finishing times. The other clause in this particular part for part-time employment is all time worked in excess of the hours agreed under clause 11.3 will be overtime and paid at overtime rates. Okay? That means for this person that worked 8 hours a day, my example, Monday, Tuesday and Wednesday, if they were called into work on Thursday, those rates would be paid at the relevant overtime rates. And we will have a look at those in a minute. However, let's have a look at a different award. Let's have a look at the Nurses Award and what that says about part-time employees. Hey, a part-time employee under this award is someone that's engaged to work less than 38 hours a week. However, unlike those rigid, strict instructions under the Clerk's Private Sector Act, the Nurses Award says before commencing, the employer and the employee will agree in writing the guaranteed minimum number of hours to be worked and the rostering arrangements that will apply to those hours. So that pretty much says, hey, if you're a part-time employee, we'll guarantee you, let's say, 3 days, 24 hours. However, because you'll be on a rotating roster and you can work up to 38 hours, if basically anything a part-timer works in excess of their guaranteed minimum hours, so even though their guaranteed minimum are only 24, they will be paid ordinary rates, not overtime rates, until they hit the 38 hours. Quite different. There's no requirement to specify the hours each day, the days of the week, or the actual hours for the part-time engagement. Under the Nurses Award, anything less than 38 hours, yep, no problem, part-time, can be worked at any time, and anything up to 38 hours is paid at ordinary rates. So once again, it's the part-time clause in awards that varies the most between the types of employment. So, I mean, for those of you who work with the Building Construction Award, you'll have you've got day workers, you've got all different types of employees, because that in itself, that award is its own legend. It's one of the most complex awards, along with manufacturing and some others. But your other awards that, you know, if you feel like reading in your spare time, by all means do so. The more simpler awards can vary and be quite different with respect to part-time employment and calculating the rate of pay, your superannuation obligations, your leave accrual obligations. So always look at the type of employment. Just because a part-time conditions apply in one award, they don't necessarily apply in another award in any way, shape or form the same. So under types of employment, in every award, modern award will also become termination of employment. And once again, we'll use the clerk's private sector because that is one of the basic awards. And what it says is that the notice of termination is provided for in the National Employment Standards. And as you can see, the table as per the National Employment Standards provides for 1 week for a year or less, 2 weeks for service between 1 and 3 years, 3 weeks for service between 3 and 5 years, and 4 weeks notice for an employee who has more than 5 years service with their employer. Now, for an employer to get that if they've been with the employer for more than 2 years, please be aware, I didn't actually specify this, but these notice periods only apply to permanent, as in part-time and full-time employees. Casuals are not entitled to notice under most awards. I believe they may have a week's notice or something like that under the construction award, but generally there's no notice required to a casual employee. Their casual loading is meant to compensate them for the absence of annual leave accruals, personal leave accruals, notice period entitlements, the notice that you're terminating them, or redundancy pay. So their loading is designed and intended to cover those 4 basic criteria. So under the National Employment Standards, you can see that the minimum notice period required, and we all are aware that an employee that has over 2 years continuous service or 2 years service and is over the age of 45 is entitled to an additional week's notice. So if you, however, look at the Professional Employees Award, in that clause it says instead of, you know, that stuff in the Fair Work Act, you know, that little table we just looked at, in order to terminate an employee, the employer must provide at least 1 month's notice. So if we go back to that previous table, if I've been there for 9 months and I'm under the Professional Employees Award, I'm entitled to 1 month's notice. I'm not entitled to 1 week, I'm entitled to 1 month. Pardon me. Now, although this bottom bit here isn't part of the award, it is a part of the National Employment Standards. So, whilst an employee is required to give an employee 1 month's notice under this award, in the event that that employee had 3 years service and was over the age of 45, they would be entitled to 1 month plus 1 week, i.e. 5.33 weeks, not 4.33 like this clause says here. Under the National Employment Standards, as a separate entitlement, employees who have been with their employer for 2 years, at least 2 years, and are over the age of 45 get the extra week. And the case was a recent one in 2015. What happened? There was an employer and the person that was kind of running the payroll, the human resource function of the business, the human resource manager, they were found to have breached the National Employment Standards. So there was an employee and he was terminated and was given 4 weeks and 3 days notice, roughly 4.33 weeks, possibly under a particular industrial instrument. Could have even been a individual contract, but let's say he was under this particular award where it said 4.33 weeks, which is roughly a month. The employee took it to Fair Work and said, hey, this employer didn't give me the minimum required period because basically I'm over 45 and I have been with the employer for more than 2 years. So it went to the Ombudsman, and it went to court and everything like that. And they found that it was a contravention of the Act. It breached the Act, and the minimum notice was 5 weeks under the Act. So what happened to the human resources manager? Well, they were, not only was the employer penalised, but their human resources manager as an individual. So not just the organisation had to pay a fine, the individual, the HR manager, was later ordered to pay a penalty of $1,020. It was noted, though, that basically the only thing that human resource manager took liability for and was deemed to have any liability in doing was issuing a letter that contained these terms and conditions. So I don't know if ignorance is bliss in this case. However, they were deemed to be involved in the contravention, because the words involved can be quite broad, and they were penalised, but it was noted that their involvement was limited to issuing the letter. So whether the employer had said to the employer, hey, you owe me an extra week, and the employer said, no, I'm not paying it, and ordered the HR manager to issue the letter, I don't know. But either way, the HR manager as an individual, was fined an amount of $1,020. Okay. Now that we've looked at the types of employment, so we've hired them either as a part-time, full-time or casual employee, and we then look at how we're going to terminate them, but after we've done that, let's see what we're going to pay them whilst they're employed. And this is usually Section 5 of your modern award. It's your minimum wages and your related matters. Sometimes your classifications are in there, sometimes, as I said, they're at a schedule with a whole long description at the end of the award. But under your minimum wages and related matters, the main things that are covered are your classifications, your minimum weekly wages, your annualised salaries, allowances, payments to juniors and stuff like that. I'm going to try and flick to the Fair Work website, because I can guarantee you this is one of your best friends. I understand bookkeepers are not in the business of processing payrolls for a living. Is it part of their role? Yes. Is it part of the accounting services they offer? Yes. But it's not your main, it's not the main part of the role that you're doing for your client. So I don't imagine that you want to sit there and read a million different clauses in 122 awards. So make the Fair Work website your best friend. We're having a look right now at what the minimum wages and related matters are under modern awards. The third one that I look at is annualised salaries. And the reason I look at this is because there was a very recent court case, I think it was in either March or May of this year, and there was an employer in the building and construction industry, and they had an employee who was employed in a clerical capacity, and they were quite correctly covered under the Clerk's Award, so everything was beautiful. So this person was told that they were going to be on an annualised salary, and the Clerk's Award certainly provides for an annualised salary. However, if you have a look at the Clerk's Award, and you can find a lot of this stuff in here for the more common industries, okay? So for the more common industries. So just as a heads up, if we were to look at the annualised salaries, we're looking at, don't forget, we're looking at minimum wages entitlement. So the stuff in the awards pretty much comes under the same sort of heading under the Fair Work website. We're looking at their pay, we're looking at their minimum wages and stuff like that. If I look at salary payments over here, you can go in there and you can have a look, and it will tell you, hey, there are some awards that allow you to annualise the salaries. And as I said, you can do this and have a look at the more common ones. And we're looking at the Clerk's Award because I'm looking at this particular case where this employee was on $78,000 a year on her contract. And this is in WA quite recently. And her contract said, you are covered under the Clerk's Award, basically, and you're on an annualised salary of $78,000, which sounds pretty fair to most of us. because common sense prevailing, we should know that $78,000 should cover, you know, your basics plus possibly any allowances and stuff like that. In order to avoid paying all relevant shift penalties and loadings and possible overtime, many employers choose to implement an annualised salary as per the award. However, if we look at the actual conditions contained in annualising a salary under this award, it says you need to show which payments will be included. So along went this girl to the Fair Work Ombudsman and she said, I know I've been paid $78,000, but I'm telling you, I used to come in very early. I used to have to work through my lunch breaks. I used to work weekends. I used to have to do this. I used to have to do that. And the employer came back in court and said, well, yeah, but those days that you stayed back, you know, you didn't have to come in until later. And, you know, when you did come in later, if you did have to work through your lunch break, you got to go home early the next day, this, that. And it went back and forth. Basically, the employee won on a technicality in that when they annualised the employee's salary, they failed to mention which payments the $78,000 covered. Did it cover overtime? Did it cover her paid breaks that she worked through? Did it cover this? Did it cover that? Nothing was in there as to what the actual salary covered, so hence the employee won. Sorry guys, I'm just looking at any more questions. No, that's not that I can see. Okay, sorry, I do have another one. So industry awards will override occupational awards? Yes. Sorry guys, I forgot to look at the questions. There's a question in here. So industry awards will override occupational awards. It is a tiered system and that's how it goes. If the classification for the role that the employee is doing is covered in the industry award, it will override the occupational award, the relevant occupational award. And then we have another question. Sorry, you were talking about. What about flexible hours for part-time? Does switching day shifts still mean overtime rates? Once again, depends on the award. Actually, where we are now, let's have a look. I'm going to try and help you work your way through the Fair Work website. Let's have a look at types of employees. So when we're seeing if when will overtime rates apply for a part-time employee? Okay, employees, types of employees. A lot of this information is here on the Fair Work website. We'll go to part-time. We'll have a look at part-time employees. And as I said, the only bad thing about this is that it does cover the most common industries. However, what you will find, if your award isn't there, where we're just about to look, and it's not one of the common industries, have a look at the clauses in it, and it could very well be phrased exactly the same as what it is in one of these common industries, in which case the same sort of terms and conditions will apply. So under the Clerk's Award, here, it gives you a nice little summary. It says the agreement has to be in writing and includes the hours worked each day, the days of the week the employees will work, and the start and finishing times. Also goes on to tell you you should keep a copy of the agreement. It also says, here you go, when can an employee's hours be changed? Yeah, by all means go ahead and change them, but only in writing. And furthermore, can you change the hours? Generally, yes, but like when they can work them, but not necessarily the number of hours. So let's see if it says anything like that. Maybe it isn't this award, sorry, I read a lot of them. Sorry, for whoever did ask that question, I will need to read the award. It doesn't look like, I mean, you can change them, but all these changes have to be in writing. And in the event that there is a roster change for people, here it is, I'm sorry, it is here. The roster for these times and dates, so your fixed hours of work. The roster for the dates and times, not the amount of hours, correct, sorry, I was right. Not the amount of hours can change. So if I was working Monday, Tuesdays, Wednesdays, 9 till 5, and they said, oh, Maria, can you do Tuesday, Wednesday, Thursday, and because someone wants to go on annual leave and we've got Monday covered, no problem. Whilst the hours and the day have changed, the day I'm working my hours, the number of hours actually hasn't changed. So you can do it. You can change the days and stuff like that, but under this award, you can't change the hours. So once again, we have 122 awards. I'm happy to have a look at another one to see if we have the Health and Professional Services Award here as a common award. Yep, we do. And we'll go to Health Support Services, and let's see what it says about part-time employees under this award. Let's see when they can change. So firstly, it's the same. It's very much the same as the Clerks Award. So the number of hours have to be specified each day, the days that the employee of the week that the employee will work, and the start and finishing times. Very similar. As you can see, it's covered by the Health Professionals and Support Services Award. It asks you, they change their hours? Yeah, of course, change the days and times, but you can't change the amount of hours worked. And I'll show you why, because when we do this, we look at the Clerks Award and the Nurses Award, which is quite different, and you'll have a look at the difference for an employee who is working in addition to their contracted hours. Don't forget the nurses just had a guaranteed minimum. They didn't say there's a maximum that you can work. Pretty much like these two awards are saying, the Clerks Award and the Health Professional Services Award are both saying, hey, part-timers, hours are fixed. Days that you work them and times may vary, but your hours are fixed. All right. My point with that one was the annualised salaries, and I did go to the questions box, so I strayed a little bit. But we keep going on with in the minimum wages and related matters. Once again, when we have a look at allowances, I had a question saying, and the question posed to me, is a first aid allowance a percentage of the employee's pay, or is it a standard amount? The answer is both, really. Because in a particular ward, the clause was the first aid allowance is X% of the standard rate. So it's a percentage of the standard rate. Now the standard rate is not the standard rate of an employee's pay. So let's try and open up an award. I will open up the Health Professional Services Award, and we'll have a look at what I doubt there'd be a first aid allowance in that one. I suspect anyone qualified under that award would already have a first aid allowance in their qualifications. Oh, we do have a first aid allowance here. Yeah. No, see, they do. They generally have. Maybe we should try the Clerks Private Sector Award for that one, sorry. If you think about the nature of the health support industry, those people have generally got some sort of certificate. Like this particular lady had their daughter's a pharmacist. Likelihood is that they've covered their first aid certificate and qualifications when they've studied or achieved their qualifications, so there's no additional pay for having a first aid allowance under that award. Let's go to the Clerks Private Sector Award. Before I do go any further, when you look at these awards, it's great to download them in PDF and print them off and stuff like that. But I can guarantee you the most current version you will get for them from the Fair Work Commission website. These go up first, and eventually they'll go to the Fair Work website, which is this one, Fair Work website. It's not the Fair Work Commission website. So if I go to the Clerks Private Sector Award and I look for a first aid allowance, I can look for any allowances. Do we have a first aid allowance? We do. And the first aid allowance says an employee who, number one, has the qualifications, and number two, is required to be the first aid officer at work. So great that you've got qualifications, but if you're not the designated first aid officer, you're not going to get this particular allowance. So what does it say about this allowance? It says it's 1.5% of the standard rate. Do you know how many people read that meaning it's a standard, the employee's standard rate irrespective of the classification? That's not the case. Once again, if we click on standard rate, it'll take you to your definitions, and in the definitions it tells you a standard rate means that rate for a level 2 year 1 employee. And when we look at that, A level 2 year 1 employee receives $783.30. So 1.5% of that's probably about $15, $16, and that's for a full-time employee. So that's for a 38-hour week. In order to get the part-time employees rate, you would divide that weekly rate, the 1.5% of the 783.30, by 38, and then multiply it by the number of ordinary hours worked by that employee. So really, let's picture the clerk's award. I work Mondays, Tuesdays and Wednesdays, and I'm the designated first aid officer. I will only get that allowance for those 24 hours, even if I do overtime on the Thursday, because it's not based, my Thursday are all overtime hours, and they are not part of my ordinary hours of work. Sorry, I do have another question here. How long can a worker be on as a casual for? We're going to have a look at that, because depending on your award and industry, there may or may not be certain terms and conditions for, pardon me, for a casual employee. So when we were looking at that Clerk's Private Sector Award versus the Nurses Award, and we've got someone, oh, where did 25 hours come from? Okay, so someone who's working 25 hours a week. Let's say they're on the same rate. Under the Clerk's Private Sector Award, they'd be getting overtime for their additional hours, and the nurse wouldn't be. So if we have a look at the overtime clause in a Nurses Award, it pretty much says that it's for hours in excess of your 38 hours a week. So the difference ends up being that one particular employee will be getting their 24 hours at their base rate of pay under the Clerk's Award, and then they would be getting time and a half for the first 2 hours that they worked on the fourth day, the Thursday, and double time for the remaining hours. A nurse will be getting their ordinary hours for all 32 hours. If that fourth day had been 8 hours, they would be getting 32 ordinary hours. However, pardon me, they would be getting leave accruals on those additional ordinary hours, and they would also be getting superannuation on those additional ordinary hours. Pardon me. Some awards also provide for time off in lieu instead of overtime. So going back to that Clerk's Private Sector Award, day 1, day 2, day 3 are worked. I'm up to day 4. It's now in overtime. There has been a recent decision at the Fair Work Commission, quite recent, and they've back at the beginning of this financial year, they introduced the ability to cash out annual leave and stuff like that. They make these big decisions. They've got another one when it comes to time off in lieu. So as the awards currently stand, there are clauses when it comes to time off in lieu, which is what people generally take when they've worked overtime. However, this new ruling, this new standard, and the standard clause that's going to be in most of the modern awards, says that time off in lieu can only be an agreement from now on in writing, but on each and every single occasion. So instead of at the beginning of my contract, I agree right at the beginning that any work that's overtime will always be time off in lieu, and I'll take it when I'm ready. It now has quite specific conditions attached to it, this time off in lieu. So number one, if I work every single time I do any overtime and I want to bank that as time off in lieu, I need to make a separate agreement with my employer in writing. The time off in lieu is now hour for hour. So if I worked 2 hours overtime, it's worth 2 hours time off in lieu. Many awards weren't quite definitive about whether it's taken off hour for hour, and if it was time and a half, you've got an hour and a half of time off in lieu. Some were different, some weren't. The standard will now be it's hour for hour. The other standard will be that that time off in lieu must be taken within 6 months or otherwise agreed. Otherwise, it's then paid out at the overtime rates. So great for an employer who's trying to work well with cash flow and stuff like that, but here's the glitch. Whilst they can keep it there for 6 months or otherwise agreed, let's say we agree to keep mine for 6 months and we're 3 months into this agreement, I can turn around right now and say, no, I want it all cashed out now and you need to pay it out at overtime rates. So the discretion is very much with the employee when it comes to time off in these new standards. Whilst it gives, you know, it does say you can do it and you can bank it for up to 6 months. Even if you agree to bank it for up to 6 months on each and every occasion, there's nothing stopping the employee reneging on that agreement. The employer can't, the employee can. So we're coming up to, oh, hang on, there was another question. Sorry, guys. How long can a worker be a casual for? We're going to look at that right now. For time off in lieu, what kind of agreement needs to be made? Great. These agreements, you know how I was talking about the entitlement to cash out leave, and the awards have a nice little template? These time off in lieu agreements are also going to have their own little template. So it will, the question is, can they put it on the timesheet? Please put 6 hours forward towards time off in lieu. I don't believe so. Each and every one will have to be a separate agreement. And I do suggest, and I know it's a pain, I really hear you, I do suggest you follow Fair Works templates. Only because they can't come and get you with anything then. Same with, before we go any further, I mean, they're not meanies. They're not going to come and eat you alive because you haven't, you know, used the template or whatever. As long as you're meeting the requirements, and instead of going and looking at what are the requirements to keep the record, use the template they've got. That way you're covered. Same goes for determining which modern award applies to you or your clients. There's nothing stopping you from writing to the Fair Work Ombudsman and asking for a private ruling. If you've been paying under the wrong award, it's not a problem. Let's just fix it. They're not going to come down on you. They will give you a ruling. And if that ruling's wrong and someone contests it, you've got an employee saying, hey, no, I'm not covered under the Horticulture Award, I'm under the Storage Services Award. You can turn around and say, no, Fair Work have ruled that you're covered under this award for this in our organisation. They're not going to come and eat you up alive. They will if you persistently do the wrong thing, yeah. Because once they audit you once, they'll keep going and going and going. All right. So can you put it on the timesheet? I would tend to say no. I wouldn't consider that a separate agreement. Sorry. There's no agreement by the employer. Nothing's been signed by the employer. Even if you signed it on the timesheet, I would tend to use the templates. I mean, great for time-saving purposes and saving the trees and everything like that. You may want to, but I would just tend to use the Fair Works templates just as a safety net. All right, let's have a look at Manufacturing and Associated Industries Award when it comes to these casual employees. So, whilst we can look at the award, and I've taken chunks out of it, the easiest way, once again, is to go back to your Fair Work website and have a look. Have a look now at casual employees. So, under many awards, okay, the Health Services Award's already up there. What does it say about casual employees? It'll tell you. They can change to full-time or part-time if the employer and the employer both agree. Is there any specific provision or requirement to give them the opportunity to take a permanent role, either part-time or full-time? Is there your employer obligation to do so? Certainly doesn't say in this award, but I can guarantee you if I was to change this to a different award, and it's quite simple, you just hit the change button to manufacturing, it's just a quick reference guide. And I take a manufacturing industry, let's have a look at what they say for casual employees. They can, and casual employees can ask to change to full-time if they've had a regular pattern of work, if they've been employed regularly for 6 months or more, and have what we tend to term regular and systematic hours. Those 3 points there pretty much cover that. If they're going to continue with regular and systematic hours, then the casual can go from part-time to full-time, and it's called a casual conversion. In fact, it's actually an obligation in that award that you must do it. If the employee fails to respond, i.e. take up the offer of part-time or full-time employment, they're deemed to have rejected it if they don't take it up, basically. So let's have a bit of a read further. After an employee has been employed as a casual for 6 months, the employer has 4 weeks to give the employee written notice telling them that they can apply for casual conversion. So it's a mandatory requirement. They can apply for casual conversion. Once that's done, the employee has 4 weeks notice to give their employer. So they can't be changed from or to casual to avoid any obligation. So you can't change them from casual to full-time to, just at a particular period of time where a particular entitlement may or may not kick in. So basically it's up to the employee to say yes or no, I want it, and for the employer to ironically approve or deny the request. Why you would have the ability to deny the request when it's a mandatory requirement that you offer them anyway. So basically the point is, yes, there are certain terms and conditions for casual employees, and it's called casual conversion, and it is in a few modern awards. The manufacturing award is the most common one, but please look at your award. As I said, the most common industries are here. We can have a look at another one. I don't imagine. Let's have a look at hair and beauty. I don't imagine there are any special provisions for that. So no, there are no specific provisions for casuals wanting to change to full-time or part-time, and there's no employer obligations to offer the casual employee who has had regular and systematic hours for a period of 6 months or more and will continue to do so. There's no obligation under this award to offer them permanency. There's another question, sorry. Well, it's a long one. Sorry. Can an employer have a new full-time employee commence on a trial basis, say 3 months, where the employer expects not to accrue annual leave entitlements during this period? No. An employee who is contracted full-time or part-time will be accrue leave entitlements. Have I seen this done? Yes. Have I seen it prosecuted? Yes. I've seen it go very horribly wrong. Can you put them on probation? Yes. If you want to enter into an agreement where you and the employee both agree that the period of probation will be deemed as a casual period of service for the purposes of personal and annual leave entitlements, you can try, but I suspect if Fair Work got a hold of it and you've got a full-time employee working 38 hours a week, unless you're paying them the relevant casual loadings and everything like that, that will be removed once the permanency period kicks in, i.e. after 3 months, I would expect them to be getting a substantially higher rate of pay to compensate them for the lack of leave entitlements. Can you do it? Is it worth? Yes, I suspect so, but once again, if you're going to go talking individual contracts, that's not under modern awards. You probably need a workplace relations lawyer or something like that to look over it. But would you do that? Is it worth it? Time, effort, and energy? In all fairness, in over a period of 3 months, an employee accrues 1 week. 1 week of leave. Is it worth the time, effort, and energy, putting them on a higher rate? There's nothing, changing their rate, changing their contract, having different terms and conditions. Is it worth the time? You look at the cost-benefit analysis of it all. I don't know. It may be worth a while, maybe not. Do you need to go and get legal advice as to whether what you're doing is compliant? It's going to cost you more. I suspect it would be easier just to accrue the entitlements. All right. I'm going to move it along, sorry. Okay. As I said, there is casual conversion clauses in some of the modern awards, and the one that we looked at was the manufacturing award. Just with casual employees, be aware, I have said this in many a presentation, be aware, it ends up costing a lot of money. Whilst it's only a few cents in each dollar, even a couple of dollars, like you need to know which casual approach to take. There's 3 ways you can do a casual loading. Well, sorry, not a casual loading, how to pay a casual employee. One is incorporating the casual loading into their base hourly rate for their normal hours. So if their normal hours were $20 an hour, their casual loading was 25%, they'd be on $25 an hour. But when they kick into overtime, the 1.5, like time and a half, only applies on the $20. You lose the casual loading. And that's the most common one, ironically called Code B, because think about this logically. When an employee is in overtime, whether they're a casual or a permanent part-time or full-time employee, neither of them are getting leave entitlements on those. None of those overtime hours count towards notice periods. None of those overtime hours count towards service or severance entitlements. So Why is the casual employee getting 25% plus time and a half? No, no, no. Sorry, casual. Like a part-time and a full-time, you're getting the base rate plus the overtime component. That's the most common way, and that's the most logical way if you think about it. When an employee is in overtime, irrespective of your employment capacity as a part-time, full-time or casual, should be on your base rate, because the entitlements the casual receives in the casual loading, that for what that casual loading is to compensate an employee, even the permanent ones aren't getting that when they're on overtime. There is an all-purpose approach where the overtime applies on the entire casual rate of pay. So if you're on $20 an hour, your casual rate is $25, your overtime is now on the $25 an hour. And there are other ones, which I think is the Hair and Beauty Industry Award, where you remove entirely, there's no casual loading applicable on any of the overtime, not even on the ordinary part. Okay, so just have a look. Once again, have a look in here, because it will tell you. It will tell you what they get paid and how to work out which loading applies. All right. Before I take any more questions, we just want to look at the consequences of getting some of these things wrong. Okay. Another very recent case. Okay, there was a particular labour hire company. So for those of you who are familiar with labour hire companies, you might have an employer in a particular industry in the manufacturing, and that's quite common. And you might have a labour hire company that only hires labour out for that industry. So the labour hire employees actually work for the labour hire company, and they get hired out to the employer. So there was a labour hire company that had all these employees. In this case, they were cleaners. Okay, and this labour hire company, right, they were unlawfully deducting something called an admin fee from the employee's wage. An admin fee for what? Processing their pay. They were also unlawfully deducting meal allowances from the employee's wages. Can't recall whether they were unlawfully deducting them because as an overpayment or unlawfully deducting them, but they never even got them in the first place. Either way, bad vibe in that environment. So what happened? Off it goes to Fair Work through an audit. So along comes a staff member possibly, or a random audit. It doesn't take much, and Fair Work went in and had a look, and not only did they find these unlawful deductions, not only did they find that the employer failed to keep these records. When they were asked to produce them and they didn't have them, the employer or staff said, yeah, we've got them somewhere, I'll get them for you. They were then fabricated and they were false, misleading or altered. Nothing on these records showed any of the deductions. So you can imagine a pay slip that shows a net pay that's different to what's gone into the employer's bank account. There's a big no-no, big no-no. So, pardon me, I did say my voice will start to go. Sorry about this, everybody. So whilst the director of the company admitted, yes, I know that we've done something wrong and we shouldn't have done it, and I knew we were doing it wrong at the time. There you go. You've got your HR person refusing to admit that they did anything wrong. So they performed further investigations, and they found that denying that they had even made a contravention. First, sorry, the Human Resources Manager denied that there was even a contravention. They said, no, we haven't done anything wrong. We're allowed to do this and whatnot. So not only did they deny there was a contravention, they were well aware that the deductions had been taking place. So the key part to this is how guilty is a person? And the law pretty much says a person who knows of a contravention, bad enough, and then takes no step to correct it is clearly, at least indirectly, in inverted commas, involved in a way by their actions or by their failure to act. They're directly or indirectly involved, and they're liable now because they have now fallen into the involved part of Section 550 of the Fair Work Act. Okay, we're running a bit early. I thought we would have had a lot more questions. Usually I've run way over, but feel free to direct any questions right now. We can look at them together. Nobody has any questions in particular that I wish to address? Oh, hang
Sorry,
on. I do have
Maria, there
another
is some
question.
questions coming
Sorry,
through there.
yeah, there is. Yeah, there is. I've seen one now. Hi, guys. One of my clients, a golf club, is a registered club. So they work under Clubs New South Wales Registered Club Award, which is, yeah, it's a really confusing award, do you think? Yeah, so they all are, sorry, award in regards to higher duties and other penalties, but bar staff which are primarily casual and to a degree green staff with their overtime and spread of hours. Okay, let's have a quick look. So I think the question is it overtime and spread of hours? Let's have a look. So they're covered under the Registered Clubs Award, I believe. Let's have a look if there is, we can look at it quickly here. In fact, the easiest way here, go into your search field here, and if you type the words when overtime applies, sorry, I can't really see because I've got a different screen blocking something else, but I've gone to when overtime applies, and if we have a quick look, hopefully we'll be able to get the Registered Clubs Award down here. So we're in hospitality. Let's see if it's a club. It's neither one of those, is it? I don't think so. No, we want the Registered Clubs Award. I don't think we're going to be able to find it in there. No, I'll have to look at that award myself and get back to you, sorry, but because it's not here. But certainly, let's say it was the Hospitality Award, which isn't really going to help you. Let's see if it'll take me to Registered Clubs. I don't think it will. No. I can tell you under the Hospitality Award, we can have a quick look. Well, that's for time off in lieu. Sorry, guys. Sorry, you wanted to know also the hours of work. So I imagine in that industry it's a 24/7 the hours of work. Maybe, maybe not. Registered clubs aren't necessarily a 24-hour operation, are they? No. Let's just remove the award. So if I did have a look at that award, I'll look it up for you. MA. We have got a bit of time, so I will get to the other questions. MA 58. Let's have a look at their overtime. So overtime is all work in excess of the hours and outside the spread of hours. So if we go up and have a look at the ordinary hours of work, that's the first thing you should be looking at, are the ordinary hours of work. Here we go. Okay, so horticultural employees, what are they? The guys that look after the greens, even though we're not even under that award. But, oh, I don't know, I'm thinking of a hospitality place, I don't know, a bar or whatever, someone looking after the greens. But under the hospitality award, I don't think there is any ordinary hours of work. It's just simply 38 a week. So there's no start and finish times, no Mondays to Fridays. No, that's just special provisions for those staff. So the hours of work can be worked pretty much at any time. So let's say we've got someone working under this award Thursday, Friday, Saturday, and someone working Wednesday, Thursday, Friday. They're doing exactly the same hours, the same rate and everything like that. There's no higher duties at this stage. They'll all get the same ordinary hours, but they'll just get a loading for their Saturday hours. There's no overtime because neither of them have done more than their 38 hours a week. Or they're not done more than their contracted rostering arrangement. So whilst we say 38 hours a week, this award does allow you to do 4 days at 9.5 hours per day. They allow you to do rostering over a 4-week period, 152 hours. So 1 week you might work 30, the next week you might work 46. So this particular award has a great flexibility when it comes to the spread of hours and any overtime entitlements. So really any overtime would be in excess of the 38 hours a week. And if you were doing that whilst you might be paying them weekly, if you were doing that on a 4-week cycle, you would wait until that 4-week cycle is up and then pay them overtime, possibly in that 4th week. Because until such time, if they're on that 4-week cycle and they work 30 hours the first week and 46 the second week and you're paying weekly, you're not going to pay them 30 for that first week. You'd be possibly paying them fortnightly. I hope that answers your quick question. Okay. What industries mandate the conversion from casual to part? What industries? Off the top of my head, I can tell you that the manufacturing, possibly the wholesale award, possibly. But if you want to send me an email as well, I'll have a look for that as well. Let's see if we've got time. Possibly even have time after these questions. Question about a client who has a Pilates studio. So fitness industry, no award seems to specifically cover the instructors or admin staff. I would tend to go with a fitness industry award. We can have a look at that one. Coverage, let's look at coverage. Yes, I agree, it's not that. I agree, it's not that. I agree, it's not that. And I agree, it's not that industry. It's her own Pilates studio. Let's see if there's a provision here for an instructor. No, because I can't spell. Instructor. Seems like there's a provision in here for an instructor. Let's have a look. No, maybe. Possibly. Are these the classifications? A level 7. It does talk about instructors. So it's indicative duty. Someone would develop in-house training programs for instructors and coordinators. I suspect they would be covered by this award. Let's have a quick look at they possibly hold qualifications. It depends also whether they hold their qualifications. Swimming safety, general supervision. I suspect those instructors aren't working under supervision. And whether or not they have the relevant qualifications. So once again, if you can't find them, to me this sounds like the most relevant award is the fitness industry for someone who has their own centre, let's say, Pilates centre that's a standalone centre and predominantly in the fitness industry, they should be covered under this award. But if you're not sure and you don't, that's purely for swimming. And depending also on their qualifications, you may not be able to classify them under this award, in which case, coaching is predominantly for swimming. You might need to apply to the Fair Work Office for a ruling as to what would cover your client. And as I said, they're not going to say, well, what have you been paying them under? I want to know, and I'm going to get you into trouble. They're not going to do that. They're there to help. The last thing they want is to, they do want their money, and they want to get the ones with the serial offenders. So if they're finding that they've audited you, or if you've asked for help, it's a common misconception that it will trigger audits. The common source of audits are generally triggered from employees who are disgruntled, not necessarily because the employer inadvertently paid under the wrong award. If they've done it and it's a clear error, or in this case, if it wasn't the fitness award and there was something else, it's a genuine mistake. They're not going to penalise you for it. They'll just say, can you pay under the right award, please? Can I ask about long service leave? How much notice do you need to give in New South Wales? Sorry, I don't know what that question means. Is it how much do you need to give in New South notice? Can I ask about how much notice do you need to give in New South Wales? Notice to what? For the employee to take leave, or the employer to direct an employee to take leave? I believe off the top of my head, it's a month. Let me just, yeah, I'm pretty sure it's a month. If it's not, yeah, I'm pretty sure it's a month. Let me just open up the Long Service Leave Act.
Maria, they have just clarified there to say the employee notice to take the leave.
The employee to take leave, the employee is entitled to tell them now. Once they become entitled to the leave, they're allowed to take it. So, sorry, I'm not sure if that helps, but let's say it's me and I have 11 years service. At 10 years I have an entitlement. I can request annual long service leave when I like. The instructions are more, I'm 99% confident of that. The instructions are more for when the employer directs an employee to take the leave. Let me open up my matrix. Sorry, let's see if it's in this, otherwise I open up the Act. I'll try and keep it in summary form because the Acts are too long to read through. Rate of pay, notice requirement. Employee entitled, here we go. Employee is entitled to take leave as soon as the entitlement arises. Employee must provide 1 month's notice. Please forgive me, I do have a life. I do not know all this legislation off by heart because I sit here and read it. It's because I've had to answer many questions. I do have a life. So yes, in New South Wales, the employee can take it when they're entitled to it. Let me go back to my quiz. Sorry about this. What industries mandate that? Okay, I don't know. The question. Are you working on a Saturday, not overtime? I think some of these have run into each other, or there's part of it missing. Because this question just says, that is, working on a Saturday, not overtime, would be 1.5 and Sundays would be 2 on the casual rate. I don't know what the rest of the question is. I'm so sorry. What defines a casual worker? Pick your award. Let's have a look. What's this award? The Fitness Industry Award. Types of employees. It's always under that 5th section usually. Sorry, 4th section. Part 3, types of employees, a casual. Under this award, a casual has these conditions. So someone who's employed to work casually and is paid as such. So basically there's certain conditions. A casual by definition and by its nature is someone that has not has not necessarily got long-term employment guarantee. The nature of casual employment means the employer requires them generally on an ad hoc basis. You may need them for a long period of time when it comes to seasonal things like coming up to Christmas, the month before Christmas, the retail month of Christmas, the month following Christmas with all the sales. You might need a casual employee working full-time hours for 3 or 4 months. It's just that the nature of a casual employee is that there's no guarantee of future employment. Whereas once you have someone permanent or part-time, it's not much more difficult to get rid of them, but there's more process involved in terminating their employment. Permanent employee generally has permanent employment. But once again, those definitions could be a lot broader or a lot less definitive depending on the award. Okay, with time off in lieu, do the same rules apply to salary employees? Same concept. For your salaried employees, have a look at what the salary arrangement covers. So I know myself, I'm contracted to do 25 hours a week. If I take time off, if I work additional hours, I have the choice either to take time off in lieu or to receive my additional pay. That's just the nature of my contract. I'm a salaried employee. Have a look at the conditions under the relevant awards. As we saw for health professionals, there may not be specific provisions or specific conditions. But in the case of that clerical employee, if you were to pay someone $80,000 a year and their relevant classification is 40, there may be something in your annualized salary arrangement that says it includes 2 hours of reasonable overtime. So having said all that, you'd have to do a reconciliation at the end of each year to make sure that you're paying at least what they would have received had they been paid directly under the award. If you pay a casual employee above the award for base hourly rate, do you have to calculate overtime from this rate, or can you revert to the award rate? Once again, it would be, if you're paying above award wages, once again, you would tend to nominate in their contract what the above or the over award payment covers. Does it cover overtime, or are you going to pay overtime at just that base rate that they've been receiving for all their ordinary hours? I've got someone right now, a member who's a client who has employees being paid under the award paid $24. The client wants to pay them $42 as a casual. Can they? By all means. Can they pay them overtime at $42 an hour? By all means. As long as when they do a reconciliation, if they were doing so much overtime, which would have to be like almost 38 hours a week, because don't forget they're almost getting double their normal rate now for their ordinary hours. So can over award payments cover overtime? Yeah, there's no problem. Once again, you need to stipulate in the contractual arrangement what the over award payment covers. My client is a retailer but does mechanical repairs to small machinery at the back of the shop. Is a retailer. So what are they selling? Repairs? Are they selling a service at the back of the shop? The mechanics would... I'm not too... It's Sue, sorry. So your client's a mechanical... Sorry, your client's a retailer. I'm just trying to picture this, a retailer. So is it something like a Repco or something, and they've got a workshop at the back, or I'm presuming it's something like that, and the mechanics would most probably be covered under their relevant award, the mechanics award. I think it's vehicle, what is it? Yeah,
Sorry,
I don't imagine that yeah?
Sue has just clarified and mentioned that it's they're selling mowers and repairing them.
Oh, mowers. Okay. I'd have to look that one up. As I said, I wouldn't know. Selling mowers and repairing them, retail sales and repairs, sales. So I don't know if these guys are qualified tradespeople, and if so, possibly then there could be 2 mechanical repairs. Yeah, I'd have to look, but if Sue can give me her email address, I'll have a look for her. I couldn't possibly tell you off the top of my head. I've got people asking about cotton ginning awards. I wouldn't have a clue about cotton ginning award either. So if you can send those specific questions, I can't tell you which award. I can guide you, but you actually need to make the, it's not necessary. It's in all cases, it's the employer who advises you which is the relevant award. But I can see that we do have small employers, and they rely very heavily on the BAS agents. I would thoroughly recommend that you simply, it's so simple. You can go into Fair Work and create an account and log in, and it's just your email address, and you can tell them, I'm a BAS agent helping a client. Could you please assist in what would be the relevant award? And they will help you. They would know better than I would what the relevant award for that particular industry is. But if you gave me one, I could look at it and tell you whether I thought it was the relevant award. Okay. Okay. This is a long one. Sorry, I can't see it. It's very long. How liable are we as contract bookkeepers when we know something is not quite correct, as business owners insist on continuing? I would, yeah, I'd say liable. Because you've now fallen into the, I'm aware that you're doing something wrong, and I'm going to keep continuing to do it. So I know it's hard because you're trying to make a living, you're trying to provide a service, and I do get it that the employers say, no, 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 no. I've got a friend who's a bookkeeper and has dropped her client because the employer is on unpaid parental leave for 12 months, but they've come back to work for 2 months, and the employer doesn't get that once you have come back and you have returned, you are no longer deemed to be on parental leave. You can't take any more. You're back at work. So do you drop your client? I don't know. I don't know how to manage that relationship, but are you liable? I suspect there would be an element of liability in there on your part, especially going now with employers, not just the company, but individuals, payroll professionals, HR managers, and there's an accounting firm. They're actually, is it an Easy Accounting? They were a Melbourne-based firm that provided outsourced payroll services and knowingly paid the wrong rate under the award simply because the client asked them to, and they got slapped with a huge fine. So I don't know how to manage the relationship between the client and yourself, and how much they don't want to follow the, the legal the necessarily compliance measures, but and remain legal. But I don't know. That's something you'd have to manage. But do I suspect that you could be liable? Yes. Okay, I was told, oops, sorry. I was told pay slips for a casual employee must include the base rate, and the loading must be shown separately on their pay slips. If your system can accommodate it, yeah, by all means. That's what the template and the specifications for the pay slip under the Fair Work regulations, the reporting requirements on a pay slip are. However, if you've got a system that doesn't accommodate that, if you're putting this information into an Excel spreadsheet and whatnot, and then printing it to PDF and handing it to the employee and stuff like that, it may not be feasible. But where you can, you certainly would, yes. And not just that, think about why you would. Because ideally, every employee, part-time, full-time or casual, should be set up on a base rate. And casual loading should be attached. So if I was a casual employee and I worked 16 hours that week, I would expect to see 16 ordinary hours and 16 hours with my casual loading. Then if I got a shift penalty and it shouldn't be on the loaded rate, that's easy because it would look at my ordinary rate and calculate the shift penalty on that. It's just when it gets difficult, like when we had in the example where the casual's base rate of pay is an all-up rate. In that case, maybe not so much. You wouldn't need to necessarily change the loading and show it as a separate loading on the payslip, because for all intents and purposes, under that particular award, the casual rate is the base rate of pay, the loaded rate. Okay, private clerks award accounting industry, compassionate leave days for part-time workers. What's the question? I'm not sure what the question is, but if you're asking about compassionate leave, under the National Employment Standards, and it would be under most awards, and under most awards it would say for compassionate leave, or please refer to the a leave is provided for as per the National Employment Standards, in which case they're entitled to 2 days for each and every occasion that they're required to take time off to look after it, either a terminally ill terminally ill family member, stuff like that. So to go to a funeral and someone's passed away, when an employee takes compassionate leave, they can take 2 days on each and every occasion. When they're a part-time worker, they can take 2 days for each and every occasion. The health support part-time roster work are not rostered to work on Saturday. If worked on Saturday, what's the ordinary rate of? I can't do those calculations right now. Okay, where you're wanting specific calculations, and where we have to read an award and have to look at that, there's no time certainly. Actually, we have to finish up right now. Sorry. We will go to the last question. If there are any questions that are specific and stuff like that, where you want a calculation for a base rate of pay and stuff like that, or overtime, please let me know. I haven't got time to do them now, sorry. So this one says 2 days after the death or the next 2 days of part-time. Yeah. Sorry, what about paid work experience in the building and construction award? Do they get super? The same superannuation rules would apply. Superannuation rules, true, there are some in certain awards that provide for more than the SG Act, but generally, if an employee is under 18, I don't know if they are or not, and not constantly working 30 hours a week, there's no requirement to pay super, or if they haven't earned $450 in the calendar month. So if it fits one of those bills, not necessarily liable for super unless there's a further provision in the building and construction award. So I'd have to look at the provision in that award. Okay, there's lots and lots of other questions. I'm so sorry, we're not going to get through them all. Sorry, guys. But if Andrew, if you could get the queries, and I'll address them at some later date, if you could get all the queries and put them in the document to me, I'll address them all for you.
That sounds perfect. Thanks, Maria. We'll definitely do that. We've got everyone's email addresses, so we'll be able to get you your answers as they come back from Maria. So we'll definitely follow that up for you. You'll also get a copy of the slides and a copy of the recording, which will be sent to you probably tomorrow. So you'll be able to refer back to the webinar at this date. So Maria, thanks so much for joining us. It's been a great, very informative hour and a half. So thank you again. And that concludes our webinar today. So thanks very much for joining us.
Thanks, everyone.